Good afternoon, one and all. Welcome to Let's Talk TCI Real Estate. As always, it's a pleasure to be in your homes on a Thursday afternoon. Just want to do one or two housekeeping matters before we get into the subject for today. Just a reminder, Let's Talk TCI Real Estate. The show is every second Thursday of the month. So just for the sake of some people who said I didn't see you last week, remember we're doing it every second Thursday, unless there's a change in schedule. That's what it is, every second Thursday. Please use this opportunity to like and share the page. Please use this opportunity to send the link, the Facebook link, to anyone you know would be interested in hearing about what we are speaking about today. Every subject is actually a subject that you can be educated on, get more information on, and it can be to your benefit. And today we are talking about generation property, something that I'm sure that we all can identify with in the Turks and Caicos Islands. So if you didn't know before, please share the link. Let someone know we are on live now. Let's talk TCI real estate. And the subject for today is about generation properties. Also, I would like to say thanks to Miss Louise Malcolm for being the previous guest on the show. We did speak about the auction process in the Turks and Caicos Islands. The feedback was really good. And for anyone who happened to miss that show, you can go back on the Facebook page or also on my YouTube channel, which is Vernica Delancey, and you will be able to view that episode about the auction process in the Turks and Caicos Islands. Remember, when you're talking about auction properties, you're also talking about foreclosed properties, just for persons who are constantly asking all real estate agents about what our foreclosed properties are on the market. That show will give you a good insight as to how you can approach those properties as they become available. Thank you once again, Miss Malcolm, for joining me on this show, the previous show. All right. So once again, like, share the page as we move right into our show. I don't like to waste much time on the introduction because there's a lot of content to cover. And also, if you have any questions, put it in the comment section, ask your questions. We will try to get through to those questions. And for any reason, if we miss them during the segment, then we will try to go back over it. And at the end of the show, also, we will have the information for our panelists today, where you can email direct if you have any of those questions, or if you are interested in moving forward with anything in this like nature to for yourself in terms of generation property, getting it resolved. So today, with great pleasure, I would like to introduce to you man of the soil in the person of George C. Mizik. He is an attorney here on island in the Turks and Caicos Islands. I'm going to help allow him at this time to do a further introduction of himself. Thank you, Mr. Mizik. Go ahead.
Thank you, Veronica, and thank you for having me. I've watched your show in the past. Congratulations on what you're doing. I think
Thank
it's
you.
good to inform and educate the public, and the information is always very important and key to growing. So thank you for being here today. I don't really like to introduce myself, but let's go. George Missick, like you said, I am an attorney at law. I'm called to the bar. That's the part I don't like to say too much because I don't like the law to define me. But in the context of this show, I've been practicing law since 2001, so this is my 20-year anniversary. I'm called to the
Congratulations.
bar. Thank you. Called to the Bar of England, called to the Bar of the Bahamas, and also called to the Turks and Caicos Bar. And so my practice has covers a vast majority of things I've done over those 20 years. A lot of litigation, a lot of real estate work, a lot of administrative probate work, and everything else that goes in there, including a lot of oftentimes pro bono work. So I have done a lot, and I'm very interested in the topic today. I'm married. I have two kids. If you want to know a bit about personally what I don't do when I do law, I enjoy sports and I do some other things. A lot of different charitable things. I like to give my time. I like to give information, and when I'm not doing law, I just like to rest. so So in a nutshell, that is what I'm doing. I have a practice, Jordan's law firm here in Provo. Previously, I worked as a partner with my firm, Karam and Missick. Now started a new firm as of 2019 called Jordan's, which is a boutique law firm here in Providenciales.
Thank you so much. Um, you don't like to introduce yourself, but you did a really good job at it. Yes. So as you would have heard that he did mention that he does practice dealing with generation property. It's always good to have an attorney um, who specializes in the field that we are talking about, because then you know that the information that is coming forward is going to be accurate information, and definitely you would be able to benefit from it. I've had a person said before, can you introduce me to a lawyer? But I want to make sure that lawyer specializes in that area that I'm interested in. And I could understand where that question is coming from. So that's why it's a pleasure having you on, because this is one of your special fields that you deal with. So it's fitting to have you on the show today to speak about generation property. So again, I will say questions, comments, please put it in the live chat, and please share this page. And when you're done, if even after the show, please share, because this is a topic that we throughout the Turks and Caicos Islands should know about, because this is something that touches home for a lot of us. All right. So I'll start by asking my first question to you. Just give a brief description of the definition of generation property.
So when we talk about generation property or generational property, as if you may, it refers to land that is owned, loaned a large tract of land, usually a large tract of land, belonging to descendants of an original land owner. So it could be many descendants of, say, a grandfather, great grandfather that have passed that owned lots of land, and you now have these descendants who are all usually claiming some sort of ownership to it, but they normally don't have any paper title to the property. So it is known that land belongs to this particular family or this particular group of people. So when we talk about generational property, it's usually this land that hasn't really been dealt with in a legal sense, but it is owned. Some persons may already be living on the land, may have homes on the land. Some, it may just be a large tract or acres of land that nothing has been done with it, but it is owned by many descendants.
So, which of the Turks and Caicos Islands, which island in the Turks and Caicos chain would you say have the most generational land that is available?
I would say that title would probably belong to Middle Caicos. I know there's a lots of land that is owned by various families. Um, a lot of land is owned, for instance, by the Forbes of Middle Caicos. So Middle Caicos, there's a lot of generational land as well in North Caicos. But I would say Middle Caicos is probably has the most land that falls. It fits that category.
Okay. So, most times when we hear about generational land, we normally hear about the terminology either administration or probation. Can you clarify what is the difference between a probate and an administration on a land for us?
Okay, so when we're talking about land belonging to a deceased, someone who's died, what normally happens if someone dies leaving land, they usually die one or two ways. They've created a will, they've actually thought about it. They have this large tract of land, or how many acres of land they have that they want to dispose of, give to their family members or their sons, daughters, whoever. And or so they do that, they hire a lawyer, they go through this process, or they do it themselves, or attempt to do it themselves, or they die without doing that. It's more likely in a lot of cases, particularly in the islands, where it's almost taboo to make a will for some people. Persons die without leaving a will. And so when we talk about probate, in a legal sense, probate is the process whereby there is a will that that expresses the wishes of the what we call the testator, the person who dies, uh, as to who gets what. So when you hear probate in a legal sense, that means there is a will involved, and that process not can go through the court, not necessarily, but that process has been undertaken, and someone is probating, applying to probate an estate. That means there's a will, they've identified, they found the will, either someone had it, a lawyer or a family member had the will, or they found the will. And when we talk about administration or a personal representative, administration is usually in what we call intestacy, where
Hmm.
intestacy is a concept where there is no will and the person dies and their estate is administered according to what the law says. In the Turks and Caicos, we have an intestacy ordinance that says if I die, who gets what, who is entitled to apply, etc. So it lays it out. The government basically tells you where this land is going, as opposed to you saying where I want it to go.
Okay, so I want to just split that in half and ask just a few questions about the will, and then I'm going to move on to the probate and then administrate. In terms of a will, does a will have to be registered to be recognized? And does it have to be like updated yearly?
The answer to that is no. Um, the main thing with wills is wills, they don't have to be registered, but they generally have to, in order to be enforceable, or if you want to go to court or you want to enforce it as a valid will, they have to comply with some formalities, what we call formalities. So some of those formalities is that the will has to be in writing. It has to be signed by a testator in the presence of two witnesses who are both present at the same time. It has to be signed at the bottom, right? There's certain formalities. If you get it wrong, it
Hmm.
can invalidate the will, or it can invalidate a gift under under the will. And so it's very important, for instance, that when one makes a will, that they're aware, and that's why normally a lawyer comes in, that there are some legal requirements, because otherwise you can die thinking that you've made a will. It turns out that a lot of disputes come up by family members or persons um, challenging the validity of a will. And so it has to be several formalities that need to be done in order to make sure that when you execute a will, it will stand up after you die. You don't have to ever touch that will again.
Okay.
You can make it, you can store it away, which isn't always a good thing, because it is good for persons too, because people, some people, when you make a will, it's likely that you will inherit or come gather more assets,
Hmm.
or you may lose some things you may dispose of. um, you may intend to give someone else, a new grandchild might be born, someone might die who you, and so it's a fluid thing that changes. And so you have oftentimes what's called a codicil, which is a sort of an amendment or addition to a will. So people tend to go back and add something, or some child or person you might fall out with. So you want to take them out the will altogether.
Correct.
And so that's why it's fluid. But again, it's important just how the will must comply with certain formalities in order to be enforceable. When you make changes to that will, it also needs to comply with certain formalities to be enforceable.
The,
And
mhm.
yes.
Yeah. No. So that does it have to be like registered with the government or anything like that?
It doesn't have to be. It can be, but it doesn't have to be. What happens sometimes in law and in life, oftentimes, particularly with COVID, for instance, you see persons going into the hospital and deteriorating very quickly, or you get falling sick very quickly, and they want to grab a pen and paper and you know
Right.
leave their will at that particular time. Again, they need to find a couple of witnesses to sign and watch and still try to comply with those formalities. But at that point, you don't have time to register a will. The what the court is concerned with is that the will expresses the wishes of the person who died. The witnesses are there to make sure that, yes, I saw so and so make this will. He appeared to be in competent, in sound mind,
Yes.
because that's another ground you find, particularly with elderly persons. One of a big challenge that usually comes up from persons who may have been disinherited or felt that they should have been included in the will is that, well, Grammy was too old. She didn't know what she was signing. She was, shouting at cars or whatever. Um, so, um, so those issues come up, and so a will is a serious document, and like I said, the challenge is being from a lawyer who also litigates. I
Hmm.
see when those things go bad. I see both sides of it. It's
Right.
supposed to be to uncomplicate things, but some wills create even more problems.
Right. But so generally, can you explain I mean, why, what's the importance of having a will? Just sum that up
So,
for us then. Yes.
so the importance of having a will, and even just to tie it in to this whole generational property, the importance of having a will is to try and get some certainty as to what asset you have. Like I said, some people really don't have anything, and they're proud to say, I'm leaving as I went. But some people other persons can amass a lot of assets, things over a lifetime. In the
Hmm.
context of generational property, the problem comes in oftentimes because, one, there isn't any real will or plan as to who will inherit the property.
Hmm.
So, for instance, you may have a grandfather, someone died 60 years ago, had thousands of acres of land, and that person died, no will, wife died, kids might have died. Those kids had kids. Some of them died. Some are alive. And now it comes down. The problem comes when people start to die off,
Hmm.
and you start going down the generations. And one day someone wakes up and say, you know what? Let me deal with this land. And so now you have this issue of trying to find out who's the brother, who's the uncle, who's the to
Hmm.
put together these family trees to find out who do I need to see who else inherits or not.
Right.
So, but a will. So, for instance, now when you say the grandfather dies, he leaves a son. He may say, "I leave my son John or to be the administrator of my estate, the executor of my estate when I die, and to give to my other children and these particular shares." So if he leaves that will, again, supposed to be a blueprint, supposed to be clear cut.
Right.
Now he leaves it to the son, and what happens in most cases, the son starts to inherit, starts to administer, or he may just sit on it, do
Hmm.
nothing, but he got the letters, the probate, and he dies. So, so now you have the land usually reverts to the back to the reverts to the grandfather.
Yes.
So who's next? It may be a next son, or it may be a grandchild in that chain who can put a link to the grandfather and say, let me take up this assignment to go back and complete this administration. So he has to go back to the court, say that grandfather died, father died, and but the land is still not, we still can't sell it because the land is still stuck in grandfather's name,
Same.
or
Correct.
and so we can't sell it, we can't go to the bank with it, we can't really do anything with it. By that time, son, we may have some other grandkids now who also have the same entitlement as the grandchild that wants to do the administration.
Right.
So the complication with generational property then becomes, when you start to go down the chain, is the court wants to know, one, who all is entitled. Are you the right person before me to make the application, or one of the persons? If you are but one of 20, a lot
Hmm.
of times the court wants to know who the other 19 are.
Right.
And they want you to get consent, some sort of consent, to see if you guys are all on the same page to administrate the estate. Because this is where um, the issue of fraud kind of comes in, and people get very um, suspicious,
Right.
yes.
So let me just stop you there for a minute, because as you start going on the chain, this is getting interesting. But I just want us to understand the terminology, so as we speak, we are
Sure,
clear
sure,
about what we're saying. So now you
sure.
are talking about the administrator of this property. So then I would like for you to explain, just for understanding purpose, who can administrate on generation land, and can you have more than one administrator? And then what are some of the advantages and disadvantages of having more than one administrator if you can? So let's
Yeah.
understand that part before we go down to fourth and fifth
Okay.
generation.
Let's
Yeah.
take them. Let's take them one at a time then. So
Yes.
who can administrate on generational property? That will vary from generational from the each fact will probably be different,
Mm-hmm.
but generally speaking, you have to be an heir. There should be some family lineage to the person who has died. So I speak about a son, grandchild, or someone coming down the line.
Sorry, does
Like
it have to be in packing order?
um, it doesn't necessarily have. Well, if they died intestate,
Mm-hmm.
again, the law says kind of gives a pecking order of who should approach the court,
Okay.
right? And so where there is, so for instance, a man dies, leaves a wife and children. Ordinarily speaking, the wife should be the spouse should be the first person entitled to apply.
Right.
Uh, the spouse dies, there's no spouse, the child, a child, all right? The court doesn't generally like multiple persons, right? So it can be a child.
Okay.
That child dies again, or there's no more, maybe another sibling. All the siblings died. Then you go to a grandchild. So it's kind of the process of elimination. You're looking for the person with the most right to um, to um, to apply, and that's usually the kinship. How close are you to the
Right.
person deceased?
So it's
That
more like
person
if
would
you're
be
a first generation versus a second generation.
right. So yeah, so first in line, the first person tends to trump the others. That's
Mm-hmm.
coming. What happens in a lot of cases though is that sometimes the person who is entitled, most entitled, is isn't interested, or they are unmotivated for whatever reason. That person isn't doing anything, or they just sat down idly by. And you have some ambitious other person who says, you know what, I need to deal with this because so and so isn't doing it. So you
Right.
may have an elder brother or sister or whoever who the family says or acknowledges as next to do it, but that person may not, for whatever reason, be motivated to do it, don't want to do it, sitting on it. And so you have someone else who decides to do it. So if you go to court in that scenario situation, you're not the person that's most entitled to do it. The court may want to know why you are here, and you may have very good reasons why. Again, no one else is doing it.
Right.
um, and you may be able to argue a case why you should do it, because the courts tend to be very practical and look at the overall paramount welfare of everyone.
Mm-hmm.
And so to hold, say, an estate ransom by one person
Mm-hmm.
um, who is appointed, and there's also power to remove people once they, even if that person has started or has been appointed by the court, if they're not doing anything or they're breaching their duties, which comes with holding that, taking on that responsibility, the court can, in certain circumstances, or another beneficiary can approach the court to ask that person for that person to be removed and replaced.
Right.
Okay. So yes, so long answer, but generally you think logically and practically. If it's my father who died, I should be the first person entitled to do. Shouldn't be my cousin or someone else or a grandchild. It should
Right.
be the son. Yes.
So can more than one person be an administrator?
More than one person can be an administrator on an estate.
Mm-hmm.
Um, generally, the general or the usual thing is probably one person, but in circumstances, um, more than one person, usually not more than two,
Okay.
can be appointed to administer on an estate. A usual situation where you find more than one person is where, for instance, there's a minors involved.
Okay.
Uh, so the court puts an extra protection, but usual number is one
Mm-hmm.
with sometimes the consent of other parties.
Mm-hmm.
And that person, despite the fact that there's only one person, that person has, like I said, they have obligations, they have responsibilities. If it's before the court, they have duties to the court.
Mm-hmm.
And so they have an obligation to account to the other beneficiaries.
Mm-hmm.
So that is one of the things also that stops these things from being administrated upon, because persons feel that, hey, if this person, if Anika gets the administrator position or she becomes executor, she's going to take everything. She's going to, or
Correct.
she, right? There's a lack of trust.
Right.
But if you understand the process, the duties, one of what that person has to account for, and
Mm-hmm.
if you be that watchdog, the other beneficiaries are that watchdog, or hold them accountable. So that person may have duties, obligations to provide me as a beneficiary with financials, with accounting, if they sell anything, with records, receipts. And so I have a duty, a right to ask for certain information, even though you're doing it and not me. So if it's one of my siblings and
Mm-hmm.
not me, I have to, I have a right to ask them and for them to produce. They have an obligation to produce certain information to me. And so that's how, rather than spend time fighting sometime on who is administered, um, beneficiaries need to understand what they can do to make sure that they are part of the process, and that they are kept in the loop of everything. Everything is done above board.
Okay. So by saying that, like you said, but the whole mistrust issue, if a beneficiary is noticed that the administrator isn't doing what they're supposed to do, can they write into the courts or can they report this administrator to have them removed?
Yes, absolutely. Absolutely. Now, I like to say the first thing you want to do is speak to that person.
Definitely, yes.
You go to them first and say, look, this isn't right, or you're not providing me with this information. But if they don't do that, yes, you do have a recourse to the courts.
Yeah. I like what you say, speak to them first, because sometimes it's just a misunderstanding because that particular person may not understand the process. They may
Right,
feel that they are not being treated fairly, whereas it's just that they're not really following line upon line what the process is.
right. And
Right. Go
yes,
ahead.
and generally they would not know the process unless, because for instance, if someone is administering, the person who is the executive or administrator may hire a lawyer, a professional, right?
All right.
The others may not have, unless they hire their own lawyers, or
Mhm. All
um,
right.
so for instance, as a lawyer, if I'm dealing with an executor of an estate, my client is the executor, right? I'm not gonna have 50 beneficiaries calling me, asking me what's going on. That's not,
Right.
the executor's role is to account to you, not me as the
Right.
lawyer, right? So sometimes some persons get their own lawyers who may be able to explain the process. Now I may help to explain the process to them,
Yes.
but in terms of giving information and taking calls every day, hey, look,
Right.
we just, yeah, no, that's not going to happen. We're going to deal with, and that's why, that's the reason why, to answer your question,
Mhm.
the disadvantages of having multiple persons sometimes is that, you have cross confusion. It
Yes.
can lead to this confusion sometimes. You want to have a lot, most times, one person responsible, accountable, and their job is to basically inform, account to the others.
Everyone else. Yes.
Yeah.
Yeah. No, that's a smart thing. Yes. Okay. So what are some of the common misconceptions you would say about generation property?
I think a misconception would be that I don't I don't believe that persons who find themselves in that situation,
Hmm.
one believe that it's a sometimes that it's a problem, it's a fixable problem. Let me put it like that. So for instance, you may have a family that has property that's worth $100 million
Right.
worth of land, And over the years, persons have just died off.
Mm-hmm.
You know, the state is worth 100 million, but you have generations after generations dying as paupers because no one is addressing their minds. They're not having the conversations. They don't know how to start sometime. And so that process never gets done. There's a misconception that, this can be fixed,
Right.
right? And then there's also the issue, and one of the next reason tied into that is the cost. Well, I don't have any money to hire a lawyer. I don't have any money to hire a surveyor because you have some of these properties when you get into it, it can become expensive.
Right.
And so persons again, what one of the things some humans do is stop themselves before they even start by saying this is an impossible task and it cannot be fixed, or I can't fix it. I don't have any money. I
Right.
don't have the education, and so and most cases I don't trust anyone else to get involved. So you have this unfortunate situation where these people die. They die holding up maybe a paper in their hand, holding a dream, and it just passes down to another generation
Right.
who don't know, often don't know what to do with the situation. So the misconception, number one, I think the main one is that there is something that can be done with it. It's about first getting the proper advice. There's problems and there's solutions.
Mm-hmm.
Um, and so you need to start having the conversations, and oftentimes the advice is free. That's the main thing, right? Now actually do the work may cost you money, but oftentimes to get that initial advice is free.
Yeah. Um, while you're talking about the challenges, I think, like you say, one of the biggest challenges among them all is the mistrust. Because even when it comes to the finance, sometimes I do believe that attorneys do work along with their clients. So even though it may be costly, I'm sure there's maybe in most instances a payment plan or something that family can go on
Yes.
that can help them to get it resolved. But I think if they can push I mean, put aside that mistrust and, like you say, just have that administrator and understand the role of the administrator and understand as beneficiaries what your power is and what you can do to make sure that that administrator stays in line. I think the process can move a bit smoother.
Yes.
So yeah. So I was just nodding my head because I was just looking at the live feed just to see if any questions had came in. A few comments, but just to see if any questions, which I'm not seeing. So they're commenting, but no questions. I guess we're giving all the right information. Yeah. So okay. So my other question is. Um, Yeah, I asked this before. In the absence of the will, how do you deal with conflict among family as to their rights? Who was first entitled to the property, and how can you give an example to illustrate? We talked a little bit about this before, but it's more so like you said. You have some relatives; they may not be like in that first generation. They may already be in that third generation, but they are excited about getting the property sorted out. So they want to skip over the second and the first generation to do so. So,
Yes.
just as a reminder for one or two people who are just coming on, what are their rights, like as a third person along the chain link reaction of this property?
Sorry, just explain that again for me. I
So
miss.
someone who, like you were saying before, when we're talking about being an administrator, we were talking about the first person will be like, say, as a father, it will go next in line to his son, right? And
Yes.
after the son, then you'll go to the second generation, probably the grandchildren. But you
Yes.
may have the grandchildren who is excited to get this process started, but you may have so many grandchildren. What is their right, if the previous generation is not trying to act upon and do anything with this land?
Right. So I guess the grandkids, like in today's world, the younger people are getting more of the education.
Hmm.
Now, not that everyone's taking advantage of it, but they have definitely have more access to it. So what you're finding though, you're finding nowadays new generation, you're finding first generations. Like I think I was a first generation lawyer in my family, right? You're
Mhm.
finding more professionals coming out of the bunch, and so you may have someone now who a realtor self who understand who can grasp more of these concept of land, and so naturally, sometimes naturally, those type of persons may gravitate to, they see a document, hey, we own all of this. That person may become sort of a leader in the group of, say, those grandkids who can either speak to an older person or speak to the others who are looking to find their way, trying to find where I'm going to find, money to start my new business or home. They realize that, hey, we have all this assets, collateral that we may be able to benefit from. I think it's having the conversation, starting off with the small conversations, probably getting one or two persons um, involved,
Mhm.
sharing some of the knowledge, because again, people like to hold on on to information, right?
Mhm.
If we know that, guess what, my cousin, all of us, this is generational property, so my entitlement isn't, really any greater than theirs. Having that conversation with them. In some instances, again, getting more information, finding another professional or someone who can help speak to the group, let them know exactly what the process is, what it is they have, identify, and give them some scenarios on how they can either get, if there's, it needs to be financed to get this sorted out. This is how some options in terms of being able to finance it. This is someone that I've used before. I know, go and speak with this person. So
Mhm.
it starts with initially with the conversation, those persons having or speaking to an older person, because sometimes people get older, they lose the will to fight, and I'm not going to benefit from the land. So
Right.
if I feel I'm older, I don't have 5, 10 years to wait for this to get cleared off. And so my motivation might not be the same as yours, who,
Right.
you're just starting a family. And so sometimes, although you're not the person at the top, one or two persons need to take the lead in those things.
Right.
Oftentimes you need to find someone who's prepared to put some skin in the game, to actually pay a professional to do something. And I find a lot of times the person who actually does that, the others gravitate around them, because oftentimes people don't want to come up off the money. So a lot of times they don't have the money.
Right.
But if you find someone, and it's like everything else, it's a matter of fairness.
Mhm.
Obviously, if I put money in to help get this, if we sell some property, I should get my money back. There's
Right.
some principles. There's some,
Yes.
you don't have to reinvent the wheel with these things,
Right.
right? But once you have an understanding of these things, I also should have said, administration can be a lot of hard work. So oftentimes, if the executive under will or administrator, they are paid reasonable fees for their services.
Okay.
So you find that person does a lot of things. They do have to attend these meetings with the professionals. They do have to go out there, walk the land, do a lot of things that the others aren't just sitting up waiting on the monies to come back.
Mhm.
So sometimes you have, hey, well, why did you take an extra $10,000? Well, because I put in, and so it's proper. It's
But that's
always
a
appropriate.
conversation they should have with the family beforehand, though.
Yes, yeah. Yes, and the family should know, again, under the law sees that as fair and reasonable. So that person
For
will
the
get,
administrator to be compensated.
exactly. Yes, they're
Okay.
doing more work to the benefit of everyone. So so whether that's a family member in that role or you hire a professional in that role, that person is expected, should be reasonably expected to get some compensation.
Okay. I have a question that's coming in. Are children born out of wedlock entitled to generational property?
Um, yes, the law has changed a lot from the archaic days when we had this concept of illegitimacy. There's no more illegitimacy under the law in terms of inheritance.
Mhm.
So once that child prove that he is an heir, or child, or grandchild under, then they have the same entitlement as the whole child of the whole breed, as we say. So there's no illegitimate, there's no half child, there's no half pregnant. You know, you you're a child, and so
You are
that,
entitled.
yeah, that's another thing that has caused problems over the years. And I just joked to myself earlier. You have some people who, when you see some people failing to acknowledge that you're related to them, or you ask, "Hey, do you know my grandmother was so and so?" And it's nope. It's usually persons trying to protect some inheritance. So they're not trying to get any new family members. They don't want any new cousins or brothers and sisters popping up. So people, it's a human thing in a lot of cases, but the law has stepped in to protect those persons who would have otherwise been disinherited in the past. So yeah.
Mm-hmm. Okay. I have another question I want to read. I'll try to read it slowly because it's a bit lengthy, just to make sure I understand it. Um, both sides of my mom family have 100 acres of land in North Caicos on her mom's side. It's not. I'm not calling any names or anything. It's just gonna
Right.
just scenario. So both sides of my mom family have 100 acres of land in North Caicos. On her mom's side, their generational land is now supposedly administered by the first grand, who lives permanently in the Bahamas. He always says how uninterested he is with anything in Turks, but he refuses to release the land papers. What can be done in this case? So that's the question. It's
Okay.
supposedly supposed to be administered by this grant, but he's refusing to release the land papers. What
So
can be done?
So in that scenario, I'm not sure which part of the process it is, whether he's actually started it or he hasn't started it at all.
Right.
Now, if he hasn't started it, and the idea of not releasing land paper, the good thing in Turks and Caicos is we have a registered land system here. And so it is fairly easy now to find out, when you say someone is holding on to land papers, it's fairly easy to do a search at the land registry if you have names and stuff to search names of persons to find out what land they have. And
Correct.
so there may be ways to get around someone who refuses to release land papers. You can, if
Mm-hmm.
you're just trying to find out the information, you can probably find it out here because registered land, there should be some records of it at the land registry.
Mm-hmm.
Now, unless it didn't get that, uh, you may have some other issues if it wasn't ever registered. But I would say the first starting point is to try and find out yourself what the properties are, because once you find that out and this person is just sitting on it, someone else may be able to start that process. And then if he's disinterested, once he hears of this process, I'm sure he's going to get up and come and see
Mm-hmm.
what's going on. So I like to be proactive in those situations. I don't like for anyone to hold me hostage on anything. So if it's someone who has documents they're holding on to, try to see how you can get that same information someplace else. If you really can get it someplace else, and he has, say, for instance, original documents that he's taken, and you believe you have some right or entitlement to it, there's processes that you most likely can invoke the court to either issue an injunction, some relief against him, in order to compel him to produce those documents. Okay,
Right.
and so without physically going over there and beating him up and taking it, uh, the law should be able to also provide you some form of that person, some sort of relief. But if there's hundreds of acres, I suspect that that's probably registered, or there's some mention on the land register. So I would start by, in Grand Turk, there's a land registry, or listing the service of a professional again who can help you to get that information, and then take it from there.
Yeah. I mean, yeah, like you said, list the services of a professional is key, especially with something like this, I do believe. Because I know we're explaining the process, but sometimes it takes you, if this is not your first line of work, sometimes it takes you a longer time to fully get the understanding.
Yeah.
So, like you said, hiring a professional, an attorney like yourself, to start the, when I say start the process, just to do the basics for you so you can know what's the next step forward is, I think is the best advice as well. Yeah. Okay. Um, I just laughed because I nudged and I saw the comment. It was a funny gesture. So when dealing with generation property, many may say that it's easier to sell instead of subdividing the land. For those who decide to not sell, right, and to divide, what happens if one person decides is not in agreement with the process and do not want the land to be subdivided? What happens in that instance?
Um, okay, so again, the courts are there really for disputes, right? And so there's rarely any type of situation that you can throw up where amongst individuals
Mhm.
that the court would not assume some jurisdiction over, or the law does not provide some type of remedy for it. So you see it, I'll give you just an example. Let's say even in a divorce, right?
Mhm.
You have a matrimonial house, you want to split, you can't decide who's going to have it. It's like the Solomon, the court generally law it's sold and the proceeds split, right?
Mhm.
As a matter, rather than have this standoff where no one is benefiting. So
Mhm.
in the case normally where you can't get agreement from parties in those type of situation, you can go to the court, and I would dare say it's more likely that court would make an order to sell. Either one person buys out the other, or you have these situations where it's sold, where persons can agree. Court always wants you to try to agree, persons to be a reasonable, but in situations where there cannot be any agreement, you have deadlock, a decision still has to be made. And like I said, in most situations, the court have will provide a decision, take a decision on what happens.
Okay, so court process. All right, I have another question. Can you put a caution on generational land? And if so, how long can the caution last on the land?
So cautions are, I mean, some cautions actually stay pretty long, but until they're removed. But if you can show, in terms of putting caution on land, and people like to put cautions on land, but to put cautions on the land, you generally have to show that you do have a beneficial interest,
Interest.
entitlement to the land. Sometimes people think they have an interest that don't have an interest. So let me let me give you an example of that. So in some cases, for instance, again, you may have whereby you have a son, daughter, a spouse involved, and you may have some grandkid or third generation person who wants to put a caution on the land. They may not have that right until their parent dies.
Mm-hmm.
Right? Because if you're not the next person in line, a lot of times you may not have the right that you think. You may have a right through someone. It's almost like a child thinking, they own the BMW, but it's mine until I die,
Exactly.
right? Or if I give it to you, and I may not give it to you, I may give it to someone else.
Right.
And so first thing if you can prove, again, and that you are, and demonstrate to the Register of Lands that you have an interest, a beneficial interest in this property that needs to be protected. Either you're under this estate, you're an heir, you have a right, you have to a third in it or whatever in it. You
Mm-hmm.
can put a larger caution on that property. And the registrar, when you put a caution, the registrar generally write to the person who is affected, who's on the title or on the land, to give notice of your caution, and to give individuals the opportunity to say why this caution should be set aside. Like I said, if it's not set aside,
Mm-hmm.
uh, they tend to remain there until, so cautions have been on properties for decades.
Because you said that, so if someone dies who puts a caution on a property, does that caution is that caution automatically removed?
Um, it may not be automatically it's not going to automatically be removed, because in most cases persons don't know, won't even know that person is dead.
Mm.
So it may be a good grounds for now if I knew is the person died to go back and write the register and say, look, this person has died. Here's their death certificate. This is, whatever interest they thought they had, unless their heirs then pick up. So you might have that. So mother dies who had an interest, that interest or that right passes down to their child. So they may say now that right is mine. And so they may try to maintain it, but it won't automatically come off. Someone will still have to make um, an application to take it off. They could use the grounds that the person died, and that may be sufficient to say okay, because generally the cause dies with people unless it's taken on by theirs.
Because otherwise, I'm thinking, wouldn't the court want to protect what if the court gave consent to put a caution on, and because they believe that that person, based on what they said, had an interest, wouldn't
Yes.
the court's duty is to protect that interest?
Yes, but if they died, then that interest, I mean, that interest, they don't have an interest anymore to protect. Right? And what might be of importance to me might not be of importance to the next person. So I still now need to, or your administrator, if you die and you left a right and someone administer your estate, they may want to take up the same cause. But you may have some cases where that person may not have left any children, they may have not left any, or whoever they left just doesn't care. So they shouldn't, the property shouldn't remain tied up just because. Um,
Because of a caution after
right,
someone passes.
exactly.
Okay. All right. So, just for the benefit, we are nearing our time here, our hour. If you have any questions last minute, please add it in the comment section at this time. Meanwhile, I'm just going to ask you one last question, and then before your closing remarks, just in case anything comes in while waiting, for someone who is interested in getting generation land sorted out, what would they need to do in order to get started on this process?
What would they need to do? Assuming that they have already identified the generational land, I think they need to do their homework. Like I had a client before that was very good. Sometimes you have clients that are very detailed. They've done all of the homework for you. So they come to the lawyer professional with their family tree. They have names. They've located everyone. So I would say first thing to try to do is to if you need advice first, go and seek that advice out. So you may need to for someone to tell you, look, start putting together the information. Who is let's start getting birth certificate, death certificates of family members, because in a lot of cases, particularly depending on how far the generation is, there's a lot of work that needs to be done, and that's the next thing that frustrates, puts people off. It's not easy. It's not for the weak. In most cases, it takes a lot of work. It takes some people skills. Sometimes you have to find family members. You have to speak with people you probably didn't want to speak with. You have to, take them out to dinner, to breakfast. You have to. So there's not always fighting. There's a lot of, you want to be very. You need something. You want something. You need to sell sell this to some family members. Some people might be on board, jump on board very easily. Others may take some convincing. You may be, you might have to be prepared to jump on a plane, a boat, to go and meet this person where they are. Yeah, again, to go because you have in Turks and Caicos, the main problem, one of the things that we didn't touch is that persons. A lot of people are in the Bahamas, they're in the U.S., they're in Europe. They're all some persons who may be very key. Now, because of technology, it's easier now to communicate if you can find them. You may have to do become a sleuth. Sometimes you have to go and Google. You have to hire investigators in some circumstances. You have to speak with some of the older people who know things that the younger people, depending on who's doing it. So some generational property issues can be very complicated in terms of, like I said, there's a lot of work that needs to be done. Sometimes it can take years to bring all of this together. And so you have to be prepared to be in it for the long run sometimes, if it is that complicated. it's worth it, but you have to, be real with what will it take to get to the next step. So you want the advice. If it's a funding issue, you need to figure out, again, try to figure out how do we fund this? We need to get a loan? We have some rich person in the family who can do it. Do we need to, find some angel investor, so, because in a lot of cases, for instance, people may have lovely beachfront property that the Ritz or whoever wants to to do a development on, and you don't want to lose that opportunity. But oftentimes, the land issues are very complicated. So, the person sometime who wants the land that badly might be prepared to put in some money in it to help finance you to sort all of this out. So you have to be creative in your thinking. um, you have to be prepared sometime to either spend some money or give up some land. um, y- you
Yes,
know
that's I know some people have
yep,
done that. You've
right.
given up some land in response to the financial part. Yep.
Yes, and some people really don't see the sense in that. And again, those people die and leave the land there. The one principle is true, is no one is going to take that land with them. And
Hmm.
so you have to do something with these land. And even generational property, it's the next point, is capable of being squatted on and being acquired by other persons legally, if you don't do anything with land. Land is something in law that the law actually takes away from you if you're not using, because that's the next misconception we miss, that you
Hmm.
have a right to just leave this land forever and do nothing with it. If the government wants it bad enough, if someone else wants it bad enough, they may just take it from you if you just sit on it and continue to do nothing with it. And so that's another reason for urgency, and why persons need to really find out how to deal with this, and just get it done. You know,
Yeah. What you said about the squatting, because with it being just lap, is now you have a squatting issue, and that creates a whole problem now getting those squatters off of the land.
yes,
Can
yeah,
they?
and
And can they? Is there? I mean, we always hear about squatters' rights.
yes.
What I mean, I'm not deviating from it, but then how long do they? You know.
Someone If someone sits on your land for 20 years here in Turks and Caicos, without your consent, they're not paying you rent. They put up a fence, they build a house. Um, you know, they use this land, they plant, they grow, do whatever on this for 20 years. They go
Hmm.
to the courts and they say, you know what, I've been on this land for 20 years.
Hmm.
And no one said anything to me. I don't have papers for this land. I've worked this land. I want title to this land. They can get that land. Um, 20 years occupation here under our laws. They can do that. And I mean, that's been done. It's not a fanciful thing. And it's not particular to the Turks and Caicos. In some cases, it's 14 years. It's even less time than the 20 years. And so land is, again, you don't take it for granted that will just stay there to benefit your great grandkids or your heirs. It may totally come out of your family's generation if persons continue to fight over it, and don't move on it. And I'm not speaking to her, and everyone's getting older, they're dying. And like I said, land is valuable. It has some land, some generational land on some of these islands, because the islands are not developed.
Hmm.
Again, some people don't want to touch it because nothing's there, no one's there, but it still has a value to it. Now, it again takes some time, the foresight, the vision, to see how we can make this land valuable. Because just how the government, the crown, has a lot of land, and they develop Provo and these other places. If
Hmm.
families, some of these families got together and start thinking of it as a government, as a corporation, and
Hmm.
persons with vision, there's no reason why they can't do the same thing that these governments are doing. You don't even have to sell the land in most cases. You can lease the land. You can do things with the land to pass down from generation to generation. Um,
Hmm.
so you don't just have generational land, but you have generational wealth, something that feeds each generation.
Yeah, but by you saying that, someone had made a comment on his saying, instead of selling our generational land, how if we start leasing our generational land the way Native Americans do? This way, the families can all benefit from the generational land for a longer period of time. And she's, I guess my question is this an option? So,
Yeah. So it is an option, but in most cases, the first thing needs to be done is the title situation with the land needs to be sorted out, because again, who is the land? If it's the land is still in the name of someone who's dead, you have a
right,
problem. It has to be in the name of a living person or living
correct,
persons in order to sell it, to lease it, to make the contract with that land. Otherwise, you're not, you can sell someone, this is my family land, but no one who, no developer, no one with money is gonna, take, if you're not on the title, they're not gonna buy it. You can't sell it. You can't sell what's not yours. Even
right.
though you have an interest in it, you really can't pass any title or anything that someone can take to the bank, to use
Hmm.
that phrase, unless you get that land regularized, which usually involves probate, some sort of administration, so that you have one executor who has the title vested in, who can negotiate, sign contracts, give authority, to lease, etc. So that's normally your first priority, is to, yes, it's generational land. Who owns it? If all the people on the title are dead, we need to figure out. We need to start administering these properties, getting together and figure out how we can sort this out legally, so that we can use and benefit from the land, other than living on it, maybe.
Okay. Um, with as an administrator in the land register, do they do you what's the word? Is it recorded on the land register who the administrator is?
Yes. Yeah. So, yes. The answer is yes. So what happens normally, if I or you take administration over a piece of property? So the property was in Grandma Jane's name,
Right.
and you administer on Grandma Jane's estate. That you register your administration on that property by what's process called transmission registration. So you will see, you send your probate, your court order up to the land register. You say, I want to be registered as the administrator, and you'll see these titles on the land certificate saying Vernica Delancey, administrator of the estate of, so land transferred into you as the administrator of the estate of and Jane. Yep. And so, but once you have that registration, you can sell that land, you can do things with that land.
Okay. All
Yeah.
right. And of course, if the administrator changes, then that also have to be updated on the land register.
Right. So that administrator dies, someone has to either probate their estate, or they have to, because again, if I'm only the administrator, most times I'm holding this in trust
Mm-hmm.
for a number of other persons,
Right.
right? So it's not my property. That's the next problem that I find as a lawyer. If one sibling dies, one sibling administers on the estate, and that sibling dies, a lot of times their kids are thinking that whole property belongs to mommy, right?
Right.
So it's only me. No, no, no. If mommy never, if mommy
Mm-hmm.
was holding it in trust for a lot of other persons, this the property, doesn't change in character. It doesn't automatically become your property. You were just an administrator, and if you die without, administering the estate properly, that property, everything basically reverts to,
Back to the
someone
original.
needs to go back, and yeah.
Okay. One last question on here. If an administrator dies and a new administrator is appointed, is the first administrator entitled to any administrative benefits?
The administrator dies.
Dies the
Sorry,
first,
again.
so then, and a
So
new
what?
administrator is appointed.
Uh-huh.
Is the first administrator who died entitled to any administrative benefits?
Benefits. No, no, well, no, they won't be, entitled to any benefits. One, they can't take any benefits because they're dead. So I
Right.
guess they're probably talking about their kids. Now, if if the administrator themselves were a beneficiary under the will or the administration, then yes, their kids could still benefit. But
Right.
if they were just an administrator, because it could be a third party administrator in some cases, with no who don't benefit under will. So then, because sometimes under will, a testator may appoint a lawyer or someone who's totally connected with the property to administrate, to be the administrator. In that
Right.
case, they only get their administrative fees or whatever else out of it.
Mhm.
They don't get any of the land, or they're not entitled to anything under the estate other than professional fees.
Right.
So yeah, so in that situation, no, they don't get anything unless they're beneficiaries, and then their kids may, again, if they die, their kids would step in, and the kid administrates their estate,
Mhm.
right? Then the kid may become a beneficiary under that same intestacy or administration.
Okay. All right. So, do you have any closing remarks, and you anything that comes to mind that you want to leave in the minds of everyone who are watching in terms of generation land do's, don't, anything that we didn't touch that you think you should put out there to everyone?
Well, I would say this because I sit from where I sit, and I'm not I'm it's not a political statement, right? But from where I sit, there's a lot of wealth in families in land. Persons are always looking for government to give them something, and I'm seeing a lot of cases where people have a lot more than they think. And by sitting, you don't need to go to government for anything. As a matter of fact, the government may need to come to some of them for certain things. And it's a matter of recognizing what you have as a collective unit. The family is a strong unit. And I think if persons act more like family, and or if you don't even want to act like family, act like a business, treat these people as your business partners, and have meetings, sit down and figure out how we can benefit for the benefit of everyone. Then there's a lot of untapped wealth, and it's just dying. It's going nowhere. And like I said, some of these islands are rich. Provo is almost at its capacity. It's a lot of the land have been sold. A lot of the people have made their monies. So logically, persons are going to look to some of these other islands in order to invest. Um, don't let the people come to invest or to do business with you not being ready to accommodate them. Now is the time to get your house in order, because I'm sure even from where you sit, this day is coming a lot sooner than anyone think. And so now is the time to deal with these generational issues, so that break the generational curse. I just came to my mind, right?
Yeah.
Generational land, break this generational curse, deal with these land, so that you can benefit for yourselves, if not for yourselves, for your a wise man leave it an inheritance for his grandkids, so that you can benefit for these persons, because life is getting harder, things are getting more expensive. It's time to monetize these lands that people have died for, they've toiled, they've worked. Don't just look at it, don't just pass by it, don't just hold on to papers. The papers don't worth anything. Get it sorted out so that you can benefit from it.
Yeah, I think that's great advice. And one or two points as you were speaking that I just grabbed out of it, like you were saying, opportunities on the outer islands. I think it is coming as well, like you said, just re-emphasizing what you said. Most of not many properties in Provo, and people are going to be extending to the outer islands. I think that where a lot of the opportunity lies at this time. And like you say, you have to be prepared, and not just prepared to say, oh, to sell your land, but prepared to develop your land. But in order to develop the land, you have to have it sorted out so you can make sure be able to do so to benefit from whatever comes in those outer islands. Yeah, and the islands are very rich, and there's a lot of untapped wealth, I think, in these generational properties. And like you said, I think persons who have these lands, they need to treat it as a business, get together and start sorting it out. Yeah. So let me ask you to please leave your contact information just for those who are listening who will probably want to get in contact with you about helping them and starting the process of, getting through to breaking these generational curses by sorting out their generational land. Please leave your information for the listening public.
My mobile number is used to be personal one time, but no more, not in these days. It's 232-7098. It's 232-7098.
Just
Uh,
don't call after hours like 9, 10 o'clock at night, please.
thought you were going to say after 6, but and my office is in the Region Village, Grace Bay. I like to
You
say
have a
behind.
Gmail as well? Yeah.
Yes, G Missick, GMISSICK at GEORDINS.com. Jordan, GEORDINS.com.
Okay, so that's gmusic at geordins.com.
That's correct.
All right. So thank you so much,
Thank
Mr.
you.
Mizik, for joining us today. It was a pleasure. I can see by the comments that a lot of people are commenting that it's very informative. I'm happy that you were able to answer those questions that were out there. And definitely, like I said to those who are listening before, please, even after we are not live anymore, please still share this feed because there are still a lot of people out there who I think this topic will hit home for them, where they are able to get a better understanding of generational property here in the Turks and Caicos Islands and be able to answer the questions that they have. Once again, thank you for joining us on the show. And I will say to all those who are listening, until next time, I would say to you, stay safe and remain blessed. Have a great afternoon.
The views, thoughts, and opinions expressed on this show belong solely to Let's Talk TCI Real Estate and not that of Keller Williams TCI or any of its affiliates. Any action you take upon the information provided on this show is strictly at your own risk, and Let's Talk TCI Real Estate guests or hosts will not be liable for any losses and damages in connection with the use of the material. I am not an investment advisor, broker, or dealer.